Good evening. Tonight we're diving into a topic that is, to put it mildly, a bit of a legal minefield: polygamy. Yes, that thing where one person has multiple spouses. Now before you start picturing some salacious reality TV show, and believe me, those exist, and they are a special kind of terrible, we're going to look at the actual laws, the boring, yet incredibly important black and white text that governs who can marry whom, and how many whoms are allowed. It's a subject that touches on everything from religious freedom and cultural tradition to women's rights and the very definition of a family unit. It's a global legal patchwork that is frankly a bit of a mess. We're going on a little world tour, a legislative safari if you will, to examine the dizzying array of laws surrounding polygamy. This isn't just about what's happening now. We'll be dusting off some historical statutes to see how we got here. From countries that have embraced it as a legally recognized form of marriage, to others that have outlawed it with the fury of 1,000 scorned spouses, the approaches are wildly different. We'll look at laws passed over a century ago, and some that are so recent the ink is barely dry. This is a story of shifting norms, political maneuvering, and deeply held beliefs clashing with the cold, hard letter of the law. So, get comfortable, because we're about to explore how different nations have tried to legislate one of the most personal and contentious aspects of human relationships. We'll see how some laws are straightforward, some are riddled with loopholes the size of a double-wide marriage bed, and others are specifically tailored for certain religious groups, creating a legal system that's less of a straight line and more of a tangled, confusing pretzel. It's a fascinating, and at times infuriating, look at how governments around the world attempt to regulate love, or at least the paperwork that comes with it. Let's begin our journey in Iraq, 1963. Now, when you think of Iraq in the 60s, you might picture political upheaval, and you wouldn't be wrong. But amidst all that, something significant happened to the institution of marriage. Before this, the legal landscape was, shall we say, restrictive. The idea of a man having more than one wife, while practiced culturally and religiously, wasn't something you could just waltz into a government office and make official with a stamp and a filing fee. It was in a legal gray area, a don't ask, don't tell situation for the state registry. But in 1963, Iraq decided to change that. They passed legislation that effectively blew the doors off the old prohibitions. This wasn't some minor tweak to an existing law. This was a fundamental reversal. The government essentially said, you know what? We're getting into the polygamous marriage business. This new law allowed for polygamous civil marriages to be legally recognized by the state. It was a formal acknowledgement, pulling the practice out of the shadows of purely religious or customary law and into the brightly lit, bureaucratic world of civil legislation. This move was significant because it codified a practice that had long existed within the cultural and religious fabric of the region. Instead of ignoring it or implicitly frowning upon it, the state chose to regulate it. The law laid out the conditions under which a man could take a second, third, or fourth wife. This wasn't a free-for-all. There were rules. Often these rules involved demonstrating the financial capacity to support multiple households or getting the consent of the existing wife. Though the enforcement of that latter point has always been, let's say, a bit inconsistent. The implications were huge. It meant that subsequent wives and their children would have legal rights and protections under civil law that they previously lacked. Things like inheritance, social benefits, and legal standing were now on the table. It was a pragmatic move, an attempt by the state to bring its legal code more in line with the lived realities of a significant portion of its population. Of course, this was and remains incredibly controversial, sparking debates about women's rights, equality, and the role of religion in state law. And so, Iraq in 1963 provides our first example of a state actively choosing to legalize and regulate polygamy. It wasn't about promoting it, necessarily, but about recognizing its existence and attempting to bring it under the umbrella of the law. It set a precedent, showing that a modern nation-state could, and would, create a legal framework for a family structure that many other parts of the world were actively trying to stamp out. It's a stark reminder that when it comes to marriage, there is no one-size-fits-all global standard. Let's fast forward to 1977 and travel to the Philippines, an archipelago of over 7,000 islands and a fascinatingly complex legal system. The Philippines is a predominantly Catholic country, a legacy of centuries of Spanish colonial rule. As you might expect, its general family law is heavily influenced by Christian traditions, which are staunchly monogamous. For most of the population, marrying more than one person is not only illegal, it's a crime called bigamy. You do it, you could go to jail. Simple as that. But, and this is a very big but, in February of 1977, the government enacted the Code of Muslim Personal Laws of the Philippines. This was a landmark piece of legislation. It essentially created a parallel legal system for the country's Muslim minority, who are concentrated primarily in the southern region of Mindanao. This code wasn't just a minor accommodation. It was a comprehensive legal framework, covering everything from marriage and divorce to inheritance and property rights, all based on Islamic jurisprudence. And right there, within that code, was the provision that made our list. The law explicitly permitted polygamous civil marriages. But, and this is the crucial part, only for Muslims. So if you're a Catholic man in Manila and you try to marry a second wife, you're looking at prison time. But if you're a Muslim man in Marawi and you meet the specific conditions laid out in the Muslim code, you can legally register a second, third, or even fourth marriage with the full backing of the state. This created a unique legal duality. The state, in effect, said that the definition of marriage depends on your religion. It was an attempt to balance national unity with respect for religious and cultural diversity. The government recognized that forcing a monogamous framework on a population that has practiced polygamy as part of its religious and cultural heritage for centuries would be not only difficult but also deeply contentious. It was a political compromise aimed at addressing the long-standing grievances of the Muslim minority and promoting peace. Of course, this solution is anything but simple. It raises all sorts of thorny questions about equality before the law. Why should a fundamental right, or crime, depending on your perspective, be determined by one's religious affiliation? Critics argue it creates a system of legal pluralism that can lead to discrimination, particularly against women, who do not have the right to be polyandrous under the code. It highlights the incredible challenge governments face when trying to create a single, unified legal system in a multi-religious, multicultural society. The Philippines provides a perfect, if complicated example of a state trying to thread a very, very fine needle. Now, let's jump to post-apartheid South Africa in 1998. This was a nation in the midst of a profound transformation, rewriting its laws to create a more just and equitable society. One of the many issues on the table was the recognition of customary marriages. For centuries, under colonial and apartheid rule, the legal system had only recognized civil or Christian marriages. The traditional marriages of the majority black population, which were often polygamous, were not legally valid. They existed outside the law, leaving spouses, especially women, and children with no legal rights or protections. In 1998, South Africa passed the Recognition of Customary Marriages Act, and it was revolutionary. The act did exactly what its name suggests. It gave full legal recognition to marriages concluded according to African customary law. And crucially, this included polygamous customary marriages. The new democratic state looked at the reality of how millions of its citizens lived and said, "This is valid. This deserves the protection of the law." It was a powerful statement of cultural recognition and a rejection of the colonial legal framework that had dismissed African traditions as primitive or illegitimate. This wasn't about legalizing future polygamous marriages in a civil sense, like in Iraq or Kenya. Instead, it was about retroactively and prospectively recognizing the validity of a pre-existing system. The law stated that if a man wanted to enter into a subsequent customary marriage, he had to apply to a court to approve a written contract that would regulate the future matrimonial property system of his marriages. This was a crucial safeguard, designed to protect the financial rights of the existing wives and ensure that they were not left destitute by the arrival of a new spouse. The debate around this law was, as you can imagine, intense. Women's rights groups were divided. Some saw it as a victory, finally giving legal standing and protection to women in customary marriages, who had previously been invisible to the law. It gave them rights to property and inheritance they never had before. Others, however, were deeply concerned, arguing that the law entrenched a patriarchal practice and that polygamy is inherently unequal and detrimental to women, regardless of the legal protections put in place. It was the classic clash between cultural rights and gender equality. Ultimately, South Africa chose a path of legal pluralism, similar in some ways to the Philippines, but based on culture rather than religion. The state recognizes multiple forms of marriage, civil marriages, customary marriages, which can be polygamous, and civil unions. It's a complex, and some would say messy system, but it reflects the country's commitment to righting the wrongs of the past and acknowledging the diverse reality of its people. It's a bold legal experiment, attempting to weave together different traditions into a single constitutional democracy. All right, let's step into the time machine and head back to the United States during the Civil War. The year is 1862. While the nation was tearing itself apart over the issue of slavery, Congress decided it had time to deal with another twin relic of barbarism, as the Republican Party platform called it. That other relic? Polygamy. At the time, the practice was most famously associated with members of the Church of Jesus Christ of Latter-day Saints, the Mormons, who had settled in the Utah Territory and were practicing plural marriage openly. This did not sit well with the federal government in Washington, D.C. To them, polygamy was not only morally repugnant, but also a threat to American values and the established social order. It was seen as an un-Christian, anti-democratic practice that degraded women and created a sort of theocratic state within a state that challenged federal authority. So, in July 1862, while battles raged in the East, President Abraham Lincoln signed the Morrill Anti-Bigamy Act into law. It was the federal government's first legislative strike against polygamy. The act was quite straightforward. It made bigamy, the act of marrying someone while already married to another person, a misdemeanor in all U.S. territories. This was key. It specifically targeted the territories, like Utah, where the federal government had direct jurisdiction, rather than the states. The punishment was a fine of up to $500 and imprisonment for up to 5 years. That's a pretty hefty penalty for the 1860s. The law also had a provision limiting the amount of property that any religious organization could own in a territory, a clear jab at the economic power of the Mormon Church. However, the Morrill Act was, initially, a spectacular failure. The federal government had a very difficult time enforcing it. Juries in Utah, often composed of Mormons, were unwilling to convict their fellow church members. For nearly 2 decades, the law was essentially a dead letter. Not a single conviction for polygamy was secured. It was a classic case of a federal law being completely undermined by local resistance. The government had drawn a line in the sand, but nobody in Utah seemed to care. This initial failure, however, only strengthened the federal government's resolve. The Morrill Act was just the opening salvo in what would become a decades-long legal and political war against polygamy in the United States. It would be followed by much harsher and more effective laws, like the Edmunds Act and the Edmunds-Tucker Act, which would eventually lead to the disincorporation of the Mormon Church and the seizure of its assets, forcing the church to officially renounce the practice in 1890. The 1862 Act was the first step, a clear declaration that in the eyes of the U.S. government, marriage was for 2 people, and 2 people only. Now, let's journey to the newly independent India of 1955. This was a nation forging its identity, drafting a new constitution, and attempting to unify a vast and incredibly diverse population under a single legal framework. One of the most ambitious and controversial reforms of this era was the Hindu Marriage Act. This was a massive piece of legislation that modernized and codified the marriage laws for the majority of the Indian population: Hindus, Buddhists, Jains, and Sikhs. And right at the heart of this act was a complete and total ban on polygamy. Before 1955, polygamy had been permissible for Hindus under certain conditions, though it was not widely practiced. The new law, however, made it unequivocally illegal. Section 5 of the Act states that a marriage can be solemnized only if neither party has a spouse living at the time of the marriage. A second marriage contracted while a first spouse is living was declared void, and the person contracting it could be prosecuted for the crime of bigamy under the Indian Penal Code. This was a radical step for India. The government, led by Prime Minister Jawaharlal Nehru, saw the ban as a crucial part of modernizing the nation and advancing women's rights. The practice was viewed as discriminatory and harmful to women, and its abolition was seen as essential for establishing gender equality within the family. It was a top-down social reform, driven by the belief that the state had a duty to legislate a more progressive and equitable society, even if it meant overturning centuries of tradition. But here's the twist, and it's a big one, much like the one we saw in the Philippines. The Hindu Marriage Act did not apply to everyone in India. The country's largest minority, Muslims, were exempted. they continued to be governed by their own uncodified Muslim personal law, which permits polygyny, a man having up to 4 wives. This created a strange legal anomaly. A Hindu man who married a second time would be a criminal, while his Muslim neighbor could do so legally. This exemption was, and remains, one of the most hotly debated topics in Indian politics. This legal divide persisted for decades until a significant verdict from the Indian Supreme Court in 2015. In a case concerning a Muslim man who had taken a second wife, the court ruled that polygamy was not an integral part of the Islamic faith. It observed that the practice was not encouraged and was subject to strict conditions that were often ignored. While the court did not outright ban it for all Muslims, its verdict strongly suggested that the practice could be outlawed without violating religious freedom, effectively extending the spirit of the 1955 ban and paving the way for future legislative action. India's story is a powerful example of the tension between secular law, religious freedom, and the quest for uniform civil rights. Just 1 year after India's move, in 1956, we find ourselves in Tunisia. Freshly independent from France, Tunisia embarked on a path of state-led modernization that was, in many ways, the most radical in the Arab world. And at the forefront of this revolution was President Habib Bourguiba, a secularist leader determined to transform his society. He wasted no time in enacting a sweeping set of laws known as the Code of Personal Status, or CPS. This code was nothing short of revolutionary for its time and place. The most dramatic provision of the CPS was a complete and unequivocal ban on polygamy. Article 18 of the code stated bluntly, "Plurality of wives is prohibited." It didn't just make subsequent marriages invalid, it made entering into one a criminal offense, punishable by a prison sentence of up to 1 year and a hefty fine. This was a direct and unprecedented challenge to a practice permitted under a traditional interpretation of Islamic law. Tunisia became the first Arab country to legislate an outright ban. Bourguiba's justification was rooted in a progressive interpretation of the Quran. He argued that the Quranic verse that permits polygamy also includes a condition that a man must treat all his wives with perfect justice. Bourguiba, and the legal scholars who supported him, contended that since treating multiple wives with perfect equality is humanly impossible, the condition can never be met. Therefore, the permission is effectively null and void. It was a brilliant piece of theological and legal reasoning, using the religious text itself to justify a secular modernist reform. This wasn't just a law on paper, it was strictly enforced. The Tunisian state made it clear that monogamy was the only legally recognized form of marriage for all its citizens, without exception. There were no religious carve-outs or customary allowances like we saw in the Philippines or South Africa. The law was universal. This move was part of a broader package of reforms within the CPS that dramatically expanded women's rights, including requiring judicial divorce instead of simple repudiation, and setting a minimum age for marriage. Tunisia's 1956 ban stands as a landmark moment. It demonstrated that an Arab, Muslim-majority nation could, through its own legislative process and theological interpretation, choose to outlaw polygamy. It set a precedent that was profoundly influential, even if few other countries in the region followed its exact path. The Tunisian model showed that there was no single, monolithic Islamic approach to family law. It remains a cornerstone of Tunisian identity and a point of pride for many, but also a subject of contention for conservative groups who see it as an infringement on religious law. Let's move to France in 1993. Now, France has a long and complicated history with polygamy, largely through its colonial past in Africa and the subsequent immigration from those regions. Polygamy is, and always has been, illegal in France itself. You cannot legally get married to more than one person on French soil. However, for many years, the government had a somewhat tolerant, if awkward, approach to immigrants who had arrived in France with multiple wives from countries where polygamy was legal. This tolerance began to wear thin in the 1980s and early 1990s, amid rising social tensions and debates over immigration and integration. The issue came to a head in the context of family reunification policies. These policies allowed legal immigrants to bring their family members, spouses and children, to live with them in France. The question was, what does family mean when a man has 4 wives and 20 children? Should the French state, which outlaws polygamy, actively facilitate the creation of polygamous households on its own territory? In 1993, the government of Prime Minister Edouard Balladur gave a resounding "non" to that question. They passed a law, often called the Pasqua Law, after the hardline Interior Minister Charles Pasqua, that drastically tightened immigration rules. A key provision of this law specifically targeted polygamy. It stated that a foreigner living in a state of polygamy in France could not only be denied a residence permit, but could have their existing one withdrawn. More importantly, the law completely outlawed family reunification for polygamous families. An immigrant who was already in a polygamous marriage was barred from bringing any of his spouses into France. The message was clear. If you want to benefit from French family reunification laws, you must abide by the French definition of a family, which is strictly monogamous. The state would no longer be complicit in what it viewed as a practice contrary to French public order and fundamental principles of gender equality. This law marked a significant shift from quiet tolerance to active prohibition. It was framed as a measure to protect women from oppressive situations and to promote the integration of immigrant communities by enforcing a single, secular, Republican model of the family. However, critics argued that the law was punitive and inhumane, effectively tearing families apart. They claimed it punished women and children for the choices of the husband, and that it was driven more by anti-immigrant sentiment than a genuine concern for women's rights. The 1993 law illustrates the complex intersection of immigration policy, family law, and cultural values in a post-colonial world. Let's hop over to Indonesia, the world's most populous Muslim-majority nation, in the year 2007. Indonesia's legal relationship with polygamy is, to put it lightly, incredibly complex. The practice is legal, but it is heavily restricted and generally frowned upon by the state. Under Indonesia's 1974 marriage law, a man who wishes to take a second wife must obtain permission from a religious court. To get that permission, he needs to prove that his existing wife is unable to fulfill her duties, has a severe illness, or is infertile, and he must have the consent of the first wife. As you can imagine, these conditions are difficult to meet, and getting that consent is often the biggest hurdle. So, while legally possible, polygamy is not easy to enter into officially. However, despite these restrictions, the practice continued, often through unregistered marriages, and it remained a subject of public fascination and controversy. This was particularly true when high-profile public figures were found to be in polygamous unions, sparking media frenzies and public debate. In 2007, the Indonesian government decided to take a very specific and targeted stand against the practice. They didn't ban it outright for everyone. Instead, they passed a regulation aimed directly at the people on the government's own payroll, the country's millions of civil servants. The law was an amendment to existing regulations on the conduct of civil servants, and it came with a very clear message. If you work for the state, you must set a good example. The new regulation explicitly banned all civil servants, from local clerks to high-ranking officials, from living in polygamous unions. It didn't matter if the marriage was religiously sanctioned or if they had court permission. If you were on the government's payroll, you were expected to be monogamous. The penalty for violating this rule was severe dismissal from public service. The government was using employment as a tool for social engineering, effectively saying, "We can't ban it for everyone, but we can ban it for our own." This move was a fascinating piece of legal maneuvering. It allowed the government to take a strong moral and ethical stand against polygamy without getting into a direct confrontation with conservative religious groups who defend the practice. It was presented as a matter of professional ethics and discipline, not religious doctrine. The argument was that civil servants must be role models, and polygamy was deemed incompatible with the image of a modern, professional bureaucracy. It was a pragmatic, if somewhat indirect way for the state to push back against a practice it found undesirable. Let's return to Iraq, but this time we're focusing on the semi-autonomous region of Iraqi Kurdistan in November 2008. While the rest of Iraq was still operating under the 1963 law that permitted polygamous civil marriages, the Kurdistan regional government decided to forge its own path. The region had its own parliament and a growing sense of distinct legal and cultural identity, and they wanted their family law to reflect what they saw as more progressive values. The Kurdish parliament passed a significant amendment to the Iraqi personal status law, which was still in effect in the region. This amendment took a dramatically different stance on polygamy. It essentially outlawed the practice, bringing Kurdistan's law more in line with countries like Tunisia than with the rest of Iraq. The new law stated that a man could not marry more than one woman, and it imposed penalties, including fines and imprisonment, for those who tried to do so. This was a major victory for women's rights activists in the region, who had been campaigning for years against polygamy. However, the law wasn't a total, absolute ban. It contained a crucial and highly controversial exception clause. The law stated that polygamy could be permitted by a judge in a few very specific and selective circumstances. These included cases where the first wife had a disease that prevented intercourse or was infertile, provided she gave her consent in court. The husband would also have to prove that he had the financial means to support another family, and that he could treat them equitably. This exception clause became a huge point of contention. While activists celebrated the general ban as a massive step forward, they were deeply worried that the exceptions created a loophole that could be exploited. They argued that women could be coerced into giving consent, and that the equity requirement was impossible to enforce, echoing the same arguments made by Bourguiba in Tunisia 50 years earlier. The result was a law that looked great on the surface, but had a potentially massive crack in its foundation. The 2008 law in Iraqi Kurdistan is a perfect example of a legislative compromise. It reflects the tension between a desire for progressive, rights-based reform and the pressures from conservative and religious elements of society. The government tried to split the difference, creating a law that was officially anti-polygamy but left a small door ajar. It highlights how even within a single country, different regions can have dramatically different legal approaches to marriage, and how the fight for women's rights often involves not just passing laws, but also closing the loopholes within them. Our final stop takes us to Kenya in March 2014. Kenya, like South Africa, is a nation with a diverse mix of cultures and religions, and its legal system has long had to grapple with the coexistence of civil law and various customary laws. For decades, polygamous marriages that were conducted under customary law were recognized as valid for the parties involved, but they existed in a separate legal sphere from civil monogamous marriages. This created confusion and left many women and children in legal limbo, particularly concerning inheritance and property rights. In 2014, Kenya decided to clean up this messy legal landscape. The parliament passed a Comprehensive Marriage Act, which was designed to consolidate the country's various marriage laws into a single piece of legislation. The bill recognized 5 different types of marriage: Christian, civil, Hindu, Islamic, and customary. And during a heated parliamentary debate, a controversial amendment was added that would have a profound impact on the nature of customary marriage in the country. The original bill stated that a man wishing to take another wife under customary law would need the consent of his existing wife or wives. However, male members of parliament successfully pushed through an amendment to remove this clause. They argued that in many traditional Kenyan cultures, a first wife's consent was not required for a man to take another wife, and forcing this requirement into the law would be an imposition of Western values. Female MPs walked out of the session in protest, but the amendment passed. When President Uhuru Kenyatta signed the bill into law, it officially and legally recognized polygamous marriages under civil law. The Marriage Act of 2014 effectively legalized polygamy for men. It clarified that marriages conducted under customary law, which can be polygamous, are just as valid as monogamous civil or Christian marriages. It was a move aimed at bringing the law in line with reality and providing legal protection for all families, regardless of their structure. The law was met with a mixture of praise and condemnation. Supporters, including many men, hailed it as a victory for African culture and tradition. They argued it simply gave legal force to what was already happening and protected women who entered into such unions from being disavowed. However, opponents, particularly women's rights groups and Christian organizations, were outraged. They saw it as a major setback for gender equality, a law that constitutionally enshrined the subjugation of women and was passed in a way that explicitly ignored their voices. Kenya's 2014 law is a very modern example of the ongoing global struggle between tradition, religion, and the evolving fight for equal rights. So there you have it. A whirlwind tour through more than 150 years of legal wrangling over one of humanity's oldest institutions. As we've seen, from the battlefields of the American Civil War to the halls of Parliament in modern-day Kenya, the legal status of polygamy is anything but static. It's a moving target, constantly being reshaped by the powerful forces of religion, tradition, nationalism, and the relentless, often messy, march toward what different societies define as progress. The laws we've looked at are a reflection of the deeply held beliefs and the political compromises that define a nation at a particular moment in time. What becomes abundantly clear is that there is no universal consensus. One country's twin relic of barbarism is another's legally protected cultural heritage. A practice outlawed as a crime in Tunisia is enshrined in civil law in South Africa. This legal patchwork demonstrates that the definition of family is not fixed. It is a concept that governments and peoples are continually negotiating and renegotiating. The laws are a battleground where competing visions of society, secular versus religious, traditional versus modern, collective rights versus individual rights, clash and, occasionally, find a way to coexist. As we move forward, these debates are certain to continue. The laws on polygamy will keep evolving, mirroring the ever-changing social, cultural, and legal attitudes of a world that is more interconnected than ever before. Issues of immigration, gender equality, and religious freedom will ensure that polygamy remains a contentious topic for lawmakers, judges, and citizens alike. The one thing we can say for sure is that the legal story of who gets to marry whom, and how many, is far from over. It's a story that's still being written, one controversial law at a time.